When investigators come calling, panic and secrecy make things worse. Clarity, logs, and boundaries make them better. In this episode, when investigators come calling, ethical data sharing and OSINT inside show teams how to respond to lawful requests, protect private people, and use open sources without becoming an internal surveillance machine. Language is neutral. Examples are composites. No legal advice, just a practical protocol you can adapt with counsel. Begin with the 3 lanes that can arrive at your door. Lane 1, law enforcement with a request, subpoena, or warrant. Lane 2, regulators or auditors with statutory powers. Lane 3, journalists or civil litigants with voluntary requests or discovery. Each lane has different authority and timelines. Your first step is classification. Who is asking, under what authority, for what data, and by when? Treat this as triage, not judgment. Build a 1-page playbook before you ever need it. Appoint a small gate team, legal, privacy, security IT, and a senior business owner. Publish a single inbox for data requests. Require that all requests be logged with date, requester, contact info, legal basis cited, scope, and deadline. Train staff to forward any incoming request to the gate team immediately. Do not let well-meaning employees answer ad hoc. A centralized log is how you avoid both under- and over-disclosure. Scope and proportionality are the heart of ethics. If the request is narrow, IP logs for user X on dates YZ. Do not hand over entire databases. If it is broad, ask clarifying questions in writing. Please confirm the specific fields, date ranges, and custodians required. Propose staged production. A small sample to confirm relevance before full extraction. Narrowing scope protects privacy and reduces the chance of producing privileged or irrelevant material. Authentication protects everyone. Verify the requester's identity via a known channel. Call a published number for the agency, not the one in the letter. Check email domains and request official reference numbers. If your company has a law enforcement portal, use it. Document verification steps in your log. If the request is urgent but the channel feels off, escalate to counsel before producing anything. Preservation before collection. As soon as a credible request arrives, issue a legal hold to relevant custodians. Do not delete emails, chats, documents, or logs related to subject dates. It should snapshot mailboxes and relevant systems. Turn off auto-deletion policies for the hold scope. Note time zones carefully. Preserves should cover the requester's stated zone plus yours. Preservation is reversible, deletion is not. Minimize by design. Use the least data that answers the question rule. Remove fields that identify uninvolved third parties where lawful, or mask them, e.g., partial emails, hashed IDs, if full detail is unnecessary. For chat exports, include timestamps and participants but consider redacting unrelated threads. For location or IP logs, provide ranges and resolution consistent with the request. If the law requires full production, say so in your cover letter. Transparency about limits and obligations builds trust. Chain of custody matters. Record who collected the data, from which systems, using which tools on what date, and how integrity was ensured, hashes, checksums, audit trails. Store exports in a secure evidence vault with access controls and automatic logging. When transferring to an external party, use encrypted channels and share keys separately. Keep copies of exactly what was produced so you can answer questions later without recreating work. Privilege and confidentiality live alongside compliance. Loop counsel early to identify attorney, client communications, and privileged work product. Segregate them. If a request appears to sweep privileged material, ask for a privilege protocol. For employee data, check contracts and local labor or privacy laws. Some jurisdictions require notification or allow employee representation. Do not promise confidentiality you cannot deliver, but do not disclose more than required. Now OSINT, the open source work you may do internally. OSINT can help validate identities, map corporate structures, and understand counterparties. Ethics require boundaries. Write a policy that says what OSINT your company may perform, for which legitimate purposes, due diligence, fraud prevention, security incidents, and what sources are off-limits, no scraping behind logins, no deception, no friending under false identities. Prohibit doxing and the collection of home addresses of private individuals unless a specific legal need exists and counsel approves. Require screenshots with URLs and timestamps so results are verifiable. Due diligence workflow in plain steps. 1. Define the question, does vendor A exist and who owns it? 2. Search official registries first, companies, tax, charity. 3. Triangulate with trade registers, sanctions lists, litigation databases, and reputable news. 4. Map directors and owners with dates, look for conflicts. 5. Save a short report with sources cited, screenshots archived, and uncertainties labeled. 6. Refresh on a cadence. High-risk vendors quarterly, others annually. OSINT becomes bureaucratic on purpose, process prevents witch hunts. Internal investigations should separate roles. Security collects system logs and device forensics under policy. HR handles interviews and employee privacy. Legal defines scope, privilege, and reporting duties. Business provides context. Avoid shadow inquiries by managers collecting private data without notice. Centralize, or you lose chain of custody and create liability. If personal devices are in scope, have a documented BYOD policy that explains when and how they can be examined and what alternatives exist, targeted collections, containerized work apps. Data localization and cross-border transfer rules complicate everything. Before exporting user or employee data to another country, check whether your privacy policy and local law allow it. Use standard contractual clauses or approved transfer mechanisms where required. If the requester is foreign law enforcement, consult counsel about treaty processes, MLATs, or local gateways. Refusing an improper path is not obstruction, it is respect for jurisdiction. Journalists deserve civility and process. If approached, acknowledge receipt, route to comms legal, and reply with a standard line. We take the matter seriously. Please direct questions to contact. Never share personal data about employees or customers without legal review and consent where required. Provide documents when they are already public or when disclosure serves a legitimate public interest and is consistent with law and policy. Off-the-record and background rules must be agreed explicitly before you speak. Employee safety sits at the center. Requests can involve allegations that stir anger online. Redact names of junior staff where lawful. Provide safety briefings and resources if employees may face harassment. Coordinate with platforms to remove doxing content. Remind managers that retaliation for good faith cooperation with investigations is prohibited and grounds for discipline. Documentation turns chaos into clarity. Keep a live register of requests, holds, productions, and deadlines. After each matter closes, run a short post-mortem. What went well, what to change in the playbook, which vendors performed, which checklists failed. Update training yearly. Practice once with a tabletop drill. Simulate a subpoena, a journalist call, and an internal fraud tip in the same week. Rehearsal builds calm. A compact response script you can adopt today. Thank you for your request. Please confirm the legal authority, exact scope, custodians, date range, data types, and preferred transfer method. We will preserve relevant data immediately. Our legal and privacy teams will coordinate production. For verification, we will follow up via the official agency switchboard. Copy legal, privacy, security, log the request, issue holds, then proceed. We close with a steady principle. Compliance and care are not opposites, they are partners. You can respect lawful authority and still protect the dignity of people whose data you hold. You can use open sources to reduce risk without turning curiosity into surveillance. The tools are simple. Centralize requests, verify, narrow scope, preserve cleanly, document chain of custody, and publish an OSINT policy that values necessity, consent, and proportionality. When the knock comes, you won't improvise, you'll execute a plan. Next time, we'll step back into the public square with trial by social media shapes perceptions of guilt and how to consume high-profile cases without becoming part of the harm. Narration generated with AI, facts verified from public sources. No legal advice is given. The purpose is education and public safety. If you have a case tip or a documented pattern to share, use a safe channel and remove personal information that could identify non-public individuals.